The case of Keli Lane has shocked the nation for over 2 decades, with the question of where is Tegan Lane? It's a mystery that still remains unsolved. The offender, Keli Lane, was born on the 21st of March 1975. She was a highly respected water polo star that dreamed of participating in the Sydney Olympics. She was an attractive, approachable person that was loved and cherished by her family and friends. No one would have ever guessed she was living a double life. The victim, Tegan Lane, was born on the 12th of September 1996. She was last seen with her mother, Keli Lane, leaving Auburn Hospital just 2 days old. Keli Lane led a secretive life, hiding a total of 3 births, in the aim to continue her career and uphold her social status. Mr. and Mrs. Lane, Keli's parents, had very high expectations of her, and they were highly respected by the community, causing Keli to hide her pregnancies. Many legal measures were taken in order to build a solid case for Keli Lane to be charged. These began in 1993, 3 years after the birth of Tegan, when Keli gave birth for the 3rd time and decided to put the child up for adoption. John Borovnik, a Department of Community Service worker, discovered Tegan was missing when he received the case due to the adoption agency being unable to contact Keli to renew the adoption contract. Docs is effective as it allowed for the law to respond to the issue, resolve the conflict, and achieve equality for all. When he contacted the hospital searching for Keli, he was revealed Keli's previous pregnancy in 1996 with Tegan. Shockingly, Keli said that was her first child. A constant issue with complying with criminal law was seen by Keli through false swearing on many occasions throughout the adoption process. Confronted in October, Keli denied the allegations of the previous 2 children. Later, changed her story saying the 2nd child lived in Perth with the birth father. John realized that Tegan was never heard of and there was no records of her. Many police were informed on the 4th of November 1999 by John to take legal action, investigate the case, and achieve justice. Detective Matthew Keogh was assigned to her in 1999, yet there was a conflict of interest due to him knowing Keli's father. The initial investigation was dismissive, limiting the enforceability of the law. This undermines the rule of law as he incompetently investigated the case, causing an injustice and imbalance of the rights of the victim. A police interview was performed by Detective Matthew Keogh on the 14th of February 2001 with Keli Lane. This evidence was used against her in hopes of charging her. During the interview, she states that she made an agreement with the child's natural father, Andrew Morris, to take custody of Tegan. After a 17-month hold, the investigation was taken over by Detective Richard Gout. A second interview took place in May 2003 where Keli changed her story, saying the natural father's name is Andrew Norris, not Morris.
Do you know the father of the child's name?
Yes, I do.
What is it?
Andrew Norris.
Morris.
Yes.
Okay.
Keli was informed about the inquiries that were going to take place and that this would go to the coroner's court. Police questioned potential witnesses for additional evidence. Tenants at the building block that Andrew Norris allegedly lived in were questioned, yet no one had heard of him. Police made inquiries with the telecommunications company and found that Keli did not have a phone till December 1996. These records were seen as irrelevant and not investigated as they fell outside the time period of interest. This demonstrates an impacting, effective use of resources, as the phone records may have held information that could have helped the investigation. There was no conflict produced based on the description Keli provided. This demonstrates the lack of resources used, as this could have been used by the media to raise awareness on the search for Andrew Norris and achieve justice. Police sniffer dogs searched for remains of baby Tegan at Duncan Gillies' previous Gladesville home, but failed to find anything. Duncan Gillies was Keli's boyfriend at the time. He was questioned and said that he was unaware that Keli was pregnant as she concealed it from him extensively. Police searched many forms of records to locate Andrew Norris, yet this never revealed him. Detective Richard Gort said police were searching for men with the name born between 1960 and 1976 as suggested by Keli. 5 men named Andrew Norris were interviewed, but there was no success. He said, "We are looking probably in the vicinity of 40 or 50 men in that age bracket." The failure of finding Tegan or Andrew Norris resulted in a coronial inquest to determine the whereabouts of Tegan. It commenced in June 2005 by Detective Sharon Rhodes and concluded in February 2006. An inquiry was ordered and a non-legal measure of media were asked to assist in the search of Tegan. School records across the country were scanned and Tegan Chapman was brought to light. Police conducted a DNA test as part of the coronial inquest on the girl, born on the same day as Tegan, and father named Andrew Alan Norris. The results found that DNA did not match to missing Tegan. Advancements in technology have allowed police investigations to become easier, and this is effective in assisting in justice being served. Birth records were also searched yet found to be incomplete due to a big gap in the information. Statistics suggest that 8,000 births were going unregistered every year in mid-1990s in New South Wales. John Abernethy, the state coroner at the time, said he concluded the coronial inquest investigation. I am comfortably satisfied that Tegan Lane is in fact deceased, yet where or how or why he couldn't say. He then recommended that the New South Wales Homicide Squad review and continue investigating the case. The lack of evidence made the investigation and search very difficult. Even after Keli admitted giving birth to Tegan, there were no traces of her or evidence to support the statement. The only type of evidence gathered with strong grounds of Tegan's existence is the hospital paperwork that stated she was discharged at 2 p.m. from the hospital with Tegan, and the video recording of Keli at her friend's wedding on the same afternoon without Tegan. Other evidence that was gathered was Keli's constant fear of her father finding out she was pregnant. This was the circumstantial evidence gathered throughout the case. It suggests Keli's motive in killing Tegan, as she was under pressure to leave the hospital and attend her friend's wedding with no one finding out. Her actions were at the cost of the rule of law, as she believed she could commit a crime and get away with it. During a phone interception of a phone call with her husband, she says, This whole mess is because I didn't have a thick skin, because I couldn't ask anyone for help, because I couldn't stand the embarrassment. Her fear of her parents' judgments and shaming them in the community led the basis of her circumstantial evidence. During Keli's third and final interview with the police on the 8th of January 2004, Keli said, There's no way, if my parents found out, that they'll let me keep her. You don't know my dad. Can you imagine what he will do? This quote displays the constant fear she had of her father. Other circumstantial evidence in Keli's case was her tendencies to keep all her pregnancies a secret and terminate and adopt the children. Nicholas Cowdery, QC, director of the New South Wales DPP at the time, said the circumstantial evidence was strong and there was enough to charge Lane with the murder of Tegan, along with 3 counts of perjury. Connecting the charges of perjury with the murder suggested that her constant lies she told were able to be proved and she was still telling a lie. Other evidence that suggests Keli murdered baby Tegan was the struggle she would have had to endure trying to raise a child and continue playing water polo. Non-legal measures taken before the offender was charged included the media as they presented the coverage of the story and promoting the search for Andrew and Tegan. News all over Australia were covering the story in hopes that someone would come forward with information on Andrew Norris or Tegan Lane. Another non-legal measure during the investigation and evidence collection taken before Keli was charged included the counsellor Keli was advised to see. This allowed for the information communicated between Keli and Denise Benfield, the counsellor, to be subpoenaed and investigated. Police thought they could reveal Keli's admission or other details in the files. Denise's recordings did not disclose any controversial information that could have been used. Instead, they suggested that Keli would have never hurt a child and she was just a young lady at the time that made a few mistakes. Therefore, the disclosure of Keli's counselling session did not balance her individual rights as her physician-patient privilege was eradicated. The Director of Public Prosecutions issued an indictment to Keli Lane on the 20th of November 2009 for the alleged murder of Tegan Lane in 1996. The charge effectively demonstrates the responsiveness of the law in resolving conflict and achieving justice. She was charged under Section 18(1)(a) of the Crimes Act 1900. Keli pleaded not guilty to the charge of murder of her 2-day-old baby and not guilty to 3 charges of perjury. The trial began on the 9th of August and commenced on the 13th of December 2010 and went for 4 months. It was held in the Supreme Court of New South Wales under the common law jurisdiction presided over by Justice Anthony Wheely. Mark Tedeschi, QC, presented a strong opening statement to the 12 jurors, stating that out of Keli's previous 5 pregnancies, 2 were terminated, 2 adopted, and 1, Tegan, allegedly murdered. The prosecution presented evidence that Keli murdered the baby because she could not look after her. She wanted to represent Australia in the Sydney Olympics in water polo. Yet the prosecution also misled the jury by including a personal theory with no evidence that the body had been dumped at Homebush Olympic site. This was withdrawn by the Crown. Due to this, Keli was offered a mistrial but denied, saying she wanted to get it over and done with. The use of a personal theory in a criminal case is highly unethical and diminishes equality and justice for the victim. Throughout the trial, the prosecution called over 75 witnesses to the stand to testify. They even told the jury that Andrew Norris was going to be called, although he never was. This displays extreme ineffectiveness in resolving conflict, as a potential crucial witness was never called. Keith Chappell, SC, Keli's defender, said during the trial they cannot prove how, when, or where, or even why Keli Lane would murder her newborn child. They can't even prove the child is dead. The trial period was very difficult for the defense as the prosecution continued to investigate and introduce and serve new material on the defense. Throughout the trial, they did not call any witnesses to present evidence, not even Keli, although they told the jury they were. Therefore, the lack of accessibility to evidence which did not exist resulted in a difficult case, which may or may not have reached a proper outcome, denying the protection of rights and equality for all. Justice Anthony Wheely had the discretion to guide the jury by making an important comment prior to the jury's deliberation, in saying, "You must not fall into the error of thinking that if a person has told a lie, then that lie in itself can prove guilt. It cannot." This is in reference to the prosecution's argument that Keli told complete and utter lies to doctors and adoption process during the period of her pregnancy. He also told the jury to consider not whether the accused is guilty, but whether the Crown has satisfied you beyond reasonable doubt that she is guilty. On 13th December 2010, after 8 days, 11 jurors decided guilty and 1 said not guilty. On the 15th of April 2011, Keli was sentenced to 18 years jail with a non-parole period of 13 years and 5 months. This strong sentencing, enforced under Section 19A of the Crimes Act 1900, is effective as it demonstrates the enforceability of the law. Keli's actions must be punished as they did not reflect the moral and ethical standards. On the 1st of March 2013, Keli was refused bail under Section 30AA of the Bail Act 1997 due to an appeal pending in the Court of Criminal Appeal against a conviction on indictment. Therefore, bail was refused in order to follow the requirements of the legislation, as this particular legislation positively ensures balance of the rights of the victim, offender, and society. The Crown appealed the matter regarding Keli's lies to the Court of Criminal Appeal on the basis that Justice Wheely had instructed the jury that Lane's lies did not equate to guilt, but the Crown stated otherwise. The Crown won its case, and prosecutor Mark Tedeschi suggested to the jury that the 3 lies were evidence of conscience of guilt. Keli's legal team lodged an appeal on the 18th of April 2011. Yet, on the 13th of December 2013, the Court of Criminal Appeal upheld the conviction. They appealed her conviction on 8 grounds, including an alternative count of manslaughter, should have been open to the jury. Her barrister, Winston Terracini, SC, appealed the case to the High Court. They told the High Court an alternative count of manslaughter should have been open to the jury, as there was no evidence about how Tegan died. Lane's second ground for appeal was that the Crown's prosecutor, Mark Tedeschi, reversed an onerous proof in asking rhetorical questions during his wrapping up of the case to the jury. The High Court rejected this on the 14th of August 2014. Keli Lane now awaits in Silverwater Women's Correctional Centre for May 2024 to apply for parole.